Henry Stern, founder of the patent law specialty firm Stern, Kessler, Goldstein, and Fox, will discuss a critically important court decision on federal patent office rulemaking.
I want to comment today on a very important decision involving inventors and their ability to obtain full patent protection for their inventions under the United States patent laws. The decision, captured Tafis v. Dahl, was handed down on March 20, 2009 by the United States Court of Appeals for the Federal Circuit and involved an appeal from a decision by Judge Kacharis of the United States District Court for the Eastern District of Virginia in Alexandria on April 1, 2008. Before I discuss Judge Kacharis's decision, let me take you back in time to early 2006. The United States Patent and Trademark Office was facing a backlog of over 700,000 patent applications. To address that backlog, the Patent Office decided to create and implement new rules of patent practice. The proposed rules sought to limit applicants in two key ways. First, the proposed rules would severely limit the number of patent claims allowed in an application or family of applications. And second, the proposed rules sought to further limit the number of patent applications in a family that could claim priority back to the date of the original application. Now a little patent law. Inventors define their inventions using what are called patent claims, which are single-sentence definitions of the legal right to exclude others from infringing, as defined by the words of the claim. Most patent applications have 20 or more patent claims because the inventor needs multiple legal definitions of the invention rights to cover all aspects, perspectives, permutations, applications, extensions, and enhancements of the basic invention concept. Patent Office examiners are charged with assessing the patentability of the claims. To fully protect even simple inventions, an inventor often has to file a series of successive patent applications based on the originally filed patent application. This practice is an integral part of the negotiation process with the Patent Office examiner over the proper scope of the claims. This patent protection regime of multiple patent filings seeking multiple claims has been in existence for over a century and is the backbone of the U.S. patent system, which is perceived by many as the best in the world. Patent Office senior management came to the conclusion in fiscal year 2004, however, that the large and growing number of patent filings in their queue was so great that they needed to limit the number of claims and refilings so as to bring the backlog under control. Moreover, they stated that the worst offenders causing the backlog were inventors that were gaming the patent system. Despite almost universal criticism from the patent community over the proposed new rules, the Patent Office moved forward with implementation. The new rules were scheduled to go into effect on November 1, 2007. However, two plaintiffs, Tafis, an individual inventor, and GlaxoSmithKline, a large multinational pharmaceutical company, brought suit against the Patent Office in the Federal District Court to challenge the rules. They argued that the Patent Office had no authority to effect such a substantive change to the patent laws and that the rules were contrary to several sections of the Patent Act. They succeeded, and on October 31, 2007, Judge Kacharis imposed a preliminary injunction that stopped the rules one day before the rules were to go into effect. After a full hearing, Judge Kacharis on April 1, 2008, imposed a permanent injunction against the rules. He essentially agreed with the Tafis and GSK position. First, holding that the Patent Office did not have substantive rulemaking authority. Further, he found that the proposed rules were inconsistent with several sections of the Patent Act and therefore exceeded the Patent Office's statutory rulemaking authority. After a full appeal hearing before the Federal Circuit, a fractured three-judge panel determined that the proposed rules were only procedural in scope, that is, not substantive, and that they were therefore within the scope of the Patent Office rulemaking authority. As to whether the rules violated the Patent Act, the panel unanimously agreed that a rule limiting the number of refilings was contrary to the patent statute, and they struck down that rule. The court then remanded the case to Judge Kacharis for further proceedings. The decision of the three-judge panel was highly fractured, with each judge writing separately. Judge Prost authored the majority opinion. She found the rules to be procedural and thus within the authority of the Patent Office. Judge Rader, however, authored the dissent. He would have found the rules to be substantive and thus outside the authority of the Patent Office. Judge Bryson authored a concurring opinion. He agreed with Judge Prost's conclusion that the rules were within the Patent Office's authority, but he relied on a different legal theory. Rather than classify the proposed rules as either procedural or substantive, he simply looked to the patent statute to determine what Congress empowered the Patent Office to do. Because Congress charted a middle course, he felt the rules lay within the Patent Office authority. Now TAFIS and GSK are asking the Federal Circuit to grant en banc review of its decision, which, if granted, would require all 12 active judges to rule on the case. Many believe that the court should grant this en banc request because the three-judge decision is fatally fractured and the proposed rules will have a substantial negative impact on current patent practice. As an attorney of an amicus group of U.S. companies that have a research and development business model that produces fundamental breakthrough inventions, my clients believe that the court should rehear the case en banc and find the rules substantive and beyond the rulemaking authority of the Patent Office. Further, we believe the rules to be contrary to several provisions of the Patent Act. Many other amici support this en banc rehearing because of the fundamental changes these rules will have. My prediction is twofold. First, I think the Federal Circuit will grant en banc review, but I am not predicting how the full court will rule. Second, I think the new director of the United States Patent and Trademark Office will rescind the rules even if the Federal Circuit finds the Patent Office had the authority to make them. The reason this will occur, in my opinion, is because the new director will have recognized that these rules are misguided and destroy the rights of inventors for perceived administrative gains, which are in fact illusory. Several former high-level Patent Office officials have told me off the record how misguided these rules are and how the Patent Office is fooling itself in thinking that these new rules would produce the pending reduction in patent application backlog. Only time will tell how all of this will come out, but it is safe to say that this case has pitted the Patent Office against the majority of the patent community in the United States.